guidelines. With regards to the pre-sentence report, Mr. McWilliams, do you have any additions, corrections, or deletions you want to make?
I do, just briefly, Your Honor. First of all, I'd like to advise the court that the pre-sentence investigation report was obtained by myself yesterday afternoon. Had a chance to review it and copy it, and this morning delivered it and memorandum from the prosecutor's office to Mr. Smith in the back, and he's had some time to review it. We've talked about it this morning. The only correction that I can see in the report right offhand is that they have Mr. Smith at one point aged at 23, and on a subsequent page they have him listed at 27.
Okay, and I think during the course of the trial he testified on several occasions that he was 23.
That's correct.
So we'll make that correction to page 1 of the under evaluation and plan.
Thank you very much.
All right.
And I think that really satisfies your question of me as to any corrections, deletions, modifications.
All right. From the people, anything to the body of the pre-sentence report?
No, Your Honor.
All right, let's deal with the sentencing guidelines.
Thank you, Judge.
Starting with prior record variable number 1 that's scored at 75 points.
Your Honor, just in general, if I might, we have two versions of scoring guidelines. One was made by the probation department, as usual, in sentencing matters. And, of course, the person that did that scoring was not privy to the trial and may have had only limited information about the trial. Those persons who were actually at the trial know certainly the factual basis for what it is that we're going to go through, and that will be the disparity so that my client knows what the difference is.
Oh, sure, I agree with that. I agree with that. And that's why I think there's value in our going through these items individually. PRV 1 is scored at 75 points. People agree?
Yes, Your Honor.
Defense?
Agree.
PRV 2 is scored at 5.
People agree, Your Honor.
Agree.
PRV 3 is scored at 0.
People agree.
Agree.
PRV 4 is scored at 5 points.
Agreed, Your Honor.
Agreed.
PRV 5 is 0.
Correct.
Correct.
PRV 6 is scored at 10 points.
Yes, Your Honor.
People agree.
And PRV 7 is 20.
I believe, Your Honor, that should be 10 points.
And I agree that it should be 10 points.
All right. For the one
Correct.
the one conviction rather than 2, because you don't count felony fines.
That is correct, yes, Your
Correct.
Honor.
All right. Okay.
So that brings the total PRV points to 105.
105, which makes it enough.
Correct.
Let's now turn to the offense variables. OV1 is scored at 25.
People agree.
Agree.
Sort of what almost sort of naturally flows from that is that 5 points are scored for OV2.
Correct.
Correct.
OV3 is scored at 25 points.
I think we disagree with that, Judge, and believe on behalf of Mr. Smith that it should be, in fact, 10.
We had originally scored that 10 points, Your Honor, but the probation department scored it 10. Fit 25, I believe that the court's discretion.
I do think that in looking at the difference, 25 points is for life-threatening or permanent incapacitating injury occurred to a victim, and I look at one of the items from the Ward Street shooting where 21 rounds were fired and the passenger did in fact receive a grazing wound to the back of the head. I think certainly that it can be categorized as a life-threatening injury. I'll make the defense objection. I'll make it 25 points.
Thank you, Your Honor.
Very well.
OV4 is scored at 0.
Your Honor, it's people's position that should be scored at 10 points. I would indicate just one particular victim in particular, Mr. Rahit, the victim from the jewelry store. He indicated, he testified that as a result of the traumatic experience of his life being threatened, that he quit his business of 16 years. He didn't go back to work ever again. He closed his shop after being in the business for 16 years. I believe that qualifies as a serious psychological injury, necessitating 10 points to be scored on OV4. There are other examples of victims who testified about the nature of their injuries. I believe Ms. Stewart, there was testimony, Hazel Stewart, there was testimony from her based on excited utterances about the effect on her age. She was an elderly woman who was a cancer patient, and the effect that it had on her not going back to her home, having to go to a relative's house. There's ample reason and justification for 10 points on OV4.
Without argument, Your Honor.
All right. I do believe that based on the impact it has had, particularly on the jewelry store owner, I do think that that does certainly qualify as a severe psychological injury, something that causes someone to close their business after 16 years because of a fear and an inability to go forward in that same line of work based on the trauma of what happened during this particular robbery. So I'll score OB4 at 10 points. OB5 is scored at 0.
Without objection.
People agree.
And there's 0 for 6. 7.
Correct. 0 for 6. On the 7, Your Honor, people wish to be heard.
Please.
We would ask the court to score 50 points on OV7. 50 points requires aggravated physical abuse. The victim was treated with sadism, torture, or excessive brutality. I would cite the court to our filing, but also the case of People v. Hornsby, which is 250 Michigan Appeal from 2012. The Court of Appeals held that 50 points was appropriate based on an armed robbery case where the defendant did not simply produce a weapon and demanded money, but cocked a weapon and repeatedly threatened the life of the supervisor and other employees of the establishment being robbed. We've had ample testimony in this case that not only were weapons used, but that victims were repeatedly told that they would be killed if they did not comply. Ms. Stewart, again, Hazel Stewart, indicated that the testimony was that if, in fact, she complies, she won't be hurt. On the Eileen robbery, the victim, Ms. Crosley, was told that if asked if she wanted to die that day, repeatedly there are victims that are told time and time again, if they comply, they will not be hurt. So it goes beyond just producing a firearm and demanding property. The people's position is that the Hornsby case justifies 50 points for extreme sadism or excessive brutality because over and over and over again during the course of these robberies, the victims were told that if they don't comply, they're going to die. And I believe that's sufficient for 50 points.
Familiar with that case, Your Honor, without objection.
All right. I do think 50 points is appropriate, and I would also point for the record and any appellate court that reviews it. I do look to what happened with regards to the Asbury Park robbery, where there was a young couple sitting in the driveway of the home where the young gentleman was robbed of his Cartier glasses and also his Rolex watch. And he was certainly put in great fear. And then after these items were taken from him, he was pistol whipped, causing certainly injury to him and also ratcheting up the fear factor. So I do believe that on OV7, 50 points is appropriate.
Your Honor, for the record, I had no objections to 0 scoring on OV6.
Okay, that's fine.
OV8, Your Honor, is scored as 0 by the probation department. People's position is should be 15 points. The OV8's factor is if a victim was taken to a place of greater danger or there's aspiratation. In this case, again, there's been ample testimony from a number of victims that they were approached in their driveway. They were taken from their driveway into their home. Some were forced to be locked in bathrooms. Some were forced to lie on the floor. Some were forced to be lied on the floor in the bedrooms while being armed. One, in fact, Mr. Rooser, the testimony was that he was taken inside his home, tied up, and held on the floor. Clearly, that's a position of greater danger. That should be 15 points for OV8.
Understood without objection.
All right, I will score 15 points for OV8. I think robbery involving Mr. Stewart as well as Mr. Rooser, I think graphically demonstrate the notion of being taken from a place outside the home where there would be people who could observe, neighbors who would at least conceptually would be able to see the victim, and they were then taken inside the house, out of sight of anyone who might be able to visibly provide aid or assistance, and that certainly places the victim in a circumstance of significantly greater danger. So OB8 will be scored at 15 points. OB9?
OB9 should be 10 points, Your Honor. Clearly, there are between 2 and 9 victims during the course of this conspiracy.
Mr. McWilliams, given the conspiracy from January through May, and certainly we have heard testimony that the conspiracy involved certainly more than 2 victims, so
Yes, Your Honor.
OB9 will be scored at 10. OB10 is scored at 0.
It is the people's position, Your Honor, that it should be 15 points as predatory conduct is involved. Again, pointing to the fact that this was a conspiracy to rob vulnerable adults. There's been testimony from Mr. Williams and Mr. Adams that it was the defendant's idea to rob senior citizens because they were vulnerable, because they're less likely to fight back, and because they would likely have more cash. There's also testimony from the Stewart robbery where there was communication back and forth by the defendant where they were lying in wait for the Stewart family because Mr. Stewart had left, and they were outside waiting, and they were taking advantage of that. That's not predatory conduct. I don't know what is, so it should be 15 points.
Your Honor, I think just because of the nature of the entirety of the, not only the circumstances, but the charge, that scoring is essentially well represented by other categories of looking at the offense variables in this matter.
All right, and I note that, Mr. McWilliams. I do think, though, that I'm required to score each individual offense variable, and in this particular case, I do think there was predatory conduct. If you look at the sentencing guidelines statute and the instructions, they talk about pre-offense conduct that was directed toward a victim. This involved circumstances where there was testimony about essentially surveillance of particular victims in this particular case. Pre-offense conduct in terms of using masks and whatnot, certainly using, I think, conduct that targeted those who were the most vulnerable, and I do think that OB10 should be scored at 15. The defense objection is noted.
Thank you.
Okay, OB11.
At 0, Your Honor,
0.
without objection.
People agree.
OB12 is scored at 0.
People would ask the court to consider scoring 25 points for OB12, Your Honor. The variables for OB12 require 3 or more contemporaneous felonious criminal acts involving crimes against a person were committed. In this case, we have that situation where we have the defendant involved in more than 3. There are a number of criminal charges that were committed by the defendant. It should be 25 points.
The incidents certainly add up, Your Honor, and speak for themselves.
All right, I do think that OB12 should be scored at 25 points. There certainly were instances of felonious conduct that were not charged and not resulted in a conviction. OB13 was scored at 25.
Agreed.
People agree, Your Honor.
OB14 is scored at 0.
We would ask the court to abide by that.
It is our position, Your Honor, that OB14 should be scored at 10 points, as the defender was a leader in a multiple offender situation. There was testimony both by Mr. Adams and Mr. Williams that the defendant was the person who came up with the idea to do the walk-in robberies, and they testified that he did not want to break into homes anymore because it was too dangerous for him. And there's other evidence that supports that, the fact that he was on parole for home invasion, the the fact that he did admit to purchasing a handgun soon after getting out of prison, all corroborate the testimony of Mr. Adams and Mr. Williams that he in fact was a leader in this situation.
I think as a leader would be defined, Your Honor, no one, because often the other parties did some of these events in the absence of Mr. Smith, that no one really can be defined as a leader in this matter.
Under OB 14 in the instructions, it says if 3 or more offenders were involved, more than one offender may be determined to be a leader. In this particular case, I think the testimony of Mr. Adams and Mr. Williams indicated that the one who had come up with the idea for the manner in which these crimes were committed was Mr. Smith. There are text messages that support that contention, where it's Mr. Smith is the one saying, don't forget the masks. He's making the inquiry about bringing the guns and bringing the magazines. I think there is ample evidence in this record to indicate that the leader of this particular group was Mr. Smith. I scored at 10 points, and I will note the defense objection.
Thank you.
OB 16 and 17 and 18 are scored at 0.
Correct.
Agreed.
Appropriately.
Yes, Your Honor.
OB 19 is also scored at 0.
Correct.
Agreed.
And OB 20 is scored at 0.
Correct, Your Honor.
Agreed.
All right.
I believe that gives us 215 total offense variable points, Your Honor, which changes the guidelines. It makes him an F on the OV level and a 6 category on the offense variable level, which the range would be 270 to 900 or life as an habitual offense.
All right. I always allow the defense to have the last word with regards to speaking at sentencing. Let me hear from the people.
Your Honor, there are a number of victims, some of whom are here today, who have prepared letters for me to read. I will read those first. I would also indicate that Judge Berg is present with his wife and supporting family members as well, and he wishes to address the court. Would you like the court to do that now or do the letters first?
We'll do the letters first.
Okay. First from Mr. and Mrs. Stewart. My sympathy and comfort for all the victims. I express sincere gratitude and appreciation to all the law enforcement agencies and the personnel of the Wayne County Prosecutor's Office and its staff for their professionalism, and Judge Kenny's court as well. Kevin Smith Jr., not to be absent from compassion. Congratulations on the birth of your baby daughter on the 24th birthday, June 28, 2016. You and your co-conspirators chose to live a life with no moral compass. I bestow ill will on you and your co-conspirators. There is a statement from the jewelry store owner, which I'll read now, Your Honor. It says that it has been over a year now since I came so close to death for the first time in my life. I remember that like it was yesterday. How can I ever forget such a day? I can't even describe the fear and the terror I felt when I saw the attacker jump over on my side of the counter in my shop with a gun in his hand. I was struggling to think of how I would survive the moment when he had fixed me to the floor. When I tried to move to press the panic button, I was hit in the back of my head, with the back of his gun on my head. That left me bleeding like a slaughtered animal. My mind froze. After that, I could not think anymore. I realized that death was near and that this was my end. These thoughts haunt me every day. I stopped going to work after that day. I had my brother open up the jewelry store for me for a month. This created so many complications for me and him, since he is a store owner himself and has family to take care of. The financial and emotional burden caused so much stress on me and my family. I thank God for keeping me alive. But this horrific incident killed my passion for the jewelry business and being a store owner after 16 years in that business. I now carry wounds and scars to remind me for the rest of my life. However, I really hope that the criminal justice system does what it is intended to do to keep criminals locked up, to ensure that our community is safe. Considering that my attacker has a long criminal history, I ask that you sentence him to the maximum sentences allowable by law. There's a letter from Hazel Stewart dated June 5th, 2015, and it's addressed to the Wayne County Prosecutor's Office. And it says, I'm writing this letter with great sadness as I recall what happened to me. In February 2015, 3 men with guns ran upon me in my driveway, forced me to open my side door while holding a gun to my head, and robbed my house. The man that appeared to be the leader said lay on the floor while the other 2 men went through the house looking for items to take. He held a gun to my head the entire time. He said, we kill people. We need money, and if you cooperate, I won't kill you. When they finished, they marched me out of my house into the cold with no coat. I was told to walk to the back. As I walked toward the garage, I thought each step would be my last. I continued walking and heard running. They left, and I was in shock. I am a cancer survivor, and for 2 years, I fought to live. I never thought I would face anything like 3 men pointing guns at me to rob me in my home. My life has changed as a result of what happened to me. I am always on guard, watching people approach me. I have had nightmares about this, and sometimes I cannot sleep. I am devastated by this act of violence, and I hope and pray that no one else will have to experience. And it's signed, a violated Mansfield Street senior citizen. At this point, Your Honor, I would inquire of the victims on Eileen Street whether they wish to make a statement. Mr. Bryant is in court. Mr. Bryant? Do you wish to address the court, sir?
Yes.
Would you like to come forward, or were you?
At the podium.
Sir.
Mr. Bryant, good morning, sir.
Good morning.
Would you give us your full name for the record, please?
Charles Bryant.
And Mr. Bryant, this is the opportunity for you to share with me how the crime has impacted you. It's not an opportunity to address Mr. Smith directly, but what would you like to share with me, sir?
I'd just like to say that I lived in Detroit since the early 70s. And this changed my life in a way where I could never get back. And I used to didn't never worry about looking over my shoulder when I come out of the house or go to work or whatever. Now, every time I make a move, I have to look around, wondering if somebody lurking in the bushes for me. And that's a hard feeling. I didn't realize all the time I spent here in Detroit, how much freedom meant. Now I realize it could be here today and gone tomorrow. And every time somebody come up to me, come behind me, I'm steady nervous and jumping, and that's a bad way to live the rest of my life. And I just hope that this young man could live long enough to repent himself and try to live a better life than what he was doing in the past. And that's all I have to say.
Thank you so much, Mr. Bryant.
Hi, my name is Sabrina Session.
Mr. Session, what would you like to say, please? Take your time.
I just want to say that the day that this happened to me changed my entire life altogether. I, too, am a cancer survivor, and I thought that was the worst thing in the world to go through. Keep on radiation and everything. But this totally messed me up all around. I don't trust anybody. I can't. The day that this happened, my youngest daughter went away. She went away for the weekend, and she was coming back that night. And she called me and told me that she was going to be later. She wanted to come the next day. And all I can picture was her coming home and finding her father and I dead in the floor from a gunshot wound. The way it all happened was just, it was horrifying and it was scary. Okay. The way he came into my bathroom and ripped my necklace off and made me take my jewelry off, it was. And then in front of my son, who's handicapped, that's all he talked about for like a month, is how the bad man came in and made mommy lay down on the floor, you know, with a gun. And this went on for like months. He would tell this to anybody that would listen to him. It's horrible and it's horrifying. I can never get back my before he entered into my life, before everything became chaotic, before anything. If I could get that back, I'd be fine. But I can't get that back. And it's just, it's hurtful. I don't trust anybody. You know, nobody. I trust nobody. If I didn't know you before, I don't want to know you after. You know what I'm saying? I'm just horrified now. He took everything away from me. My sense of security in my own home, in my bathroom. I mean, it's just bad.
Thank you.
And I can't get it back.
Thank
Good morning. My name is Terrence Berg. May it please the court, thank you for giving me the opportunity to speak. I do want to start by saying that my family and I are extremely grateful for the hard work of the Detroit Police Department and the Wayne County Prosecutor's Office and the federal task force agents, all the work they put into this case that resulted in the successful prosecution of Mr. Smith and his co-defendants. The great, excellent police work that they did stopped a very dangerous group, and we're grateful for that. Mr. Moran told me that the victim statement might talk about how a victim has been harmed or how his life has been changed, and I understand and I agree and certainly sympathize with the statements that the other victims have made about their sense of security. I've given a lot of thought to this. I realize our case was only a small fraction of the criminal conduct that was presented in the trial. The court already heard the testimony about my own injury, and I have nothing to add to that. And there have been negative consequences, but there have been some positive consequences as well. If, because of what happened to me, Mr. Smith and his entire armed robbery ring was caught, then that's a very positive consequence in terms of the dangers that they were causing in our community. Second, although I also have to admit that I get nervous when I see two strangers approaching me on the street, more nervous than I did before, I have to say that other things have happened that have also given me a lot of confidence and a lot of respect for the people in my neighborhood and for the people of Detroit. I can't count the times I've been walking in my neighborhood since this happened, and a car might roll up and the window would come down and I might start to get a little bit nervous. But instead of anything bad, the person inside says something like, "Hi, Judge, how are you doing? Glad to see you walking. We've been praying for you." And that still happens. That still happens very frequently. So, although, yes, there is more of a sense of fear, I also feel surrounded by support, and my family feels surrounded by support, because, thank goodness, the majority of the people of Detroit are that way. And they express love, not selfishness, empathy and sympathy for someone who is hurt, not a cold-hearted desire to hurt others for self-gain, kindness, not brutality, support and embrace for the whole community, not violence against the vulnerable. I'm not saying that we don't have a violent crime problem. I know that we do. But I'm saying that the bad guys are substantially outnumbered by the good guys. I know it was the bad qualities that were on display during the trial that we had in this case, and I'm sure the court is taking all that into account in determining what the sentence should be. But I want to say that I do believe it's possible for people to change. I know that I've changed and grown because of what's happened to me, and it's been in a positive way. That statement that whatever doesn't kill you makes you stronger is true. My wound is mainly healed. It went from being shattered and useless leg to being solid and strong. A person can heal too. I'm sure Your Honor will impose a fair and just sentence, whatever sentence you impose. My hope here is that Mr. Smith can somehow heal and change and turn his life around, just as I hope the cycle of violence that plagues our city can also be turned around. I want to thank you for the opportunity for addressing the court.
There are other victims present who do not wish to address the court, Your Honor. I just let the record reflect that there are a number of them who are here for the purpose of observing the sentence. So with that, we have no additional victim impact statements. May I address the court as what I believe would be an appropriate sentence?
Please.
Your Honor, the people that submitted a sentencing memorandum, and I won't belittle the points that were made therein, but I would just indicate a couple of things. The sentencing guidelines are large in this case. They are up to 75 years or life for the defendant. But those are guidelines that he earned. He earned them by his conduct, by his behavior, by his criminal history, by his violations of his parole history, by everything that he's done in his life, the decisions that he has made. So those guidelines were earned by his conduct. But what the guidelines don't reflect are a number of things. First, the testimony of the defendant. The court heard him testify, and he lied. He committed perjury. He indicated that he lied, that he raised his hand and told untruths. And then time and time again, he denied any involvement in spite of the overwhelming physical evidence that corroborates him. For example, the Ward Street robbery, where he said he wasn't there, but his gun was there and his cell phone was there 3 minutes before the robbery took place, the shooting on Ward Street. So again, he lied. The guidelines don't reflect that. The guidelines don't reflect the careless attitude and the disregard for the criminal justice system that the defendant has had. He was on parole for home invasion. Freshly 15 minutes out of prison, he decides that he's going to buy a gun. He decides that he's going to continue his criminal ways, not by doing home invasions, which is what got him to prison in the first place, but by victimizing senior citizens, by buying a gun and robbing people. And he didn't stop at one gun, he bought 2 guns. He didn't stop at 2 guns, he had laser pointers. He had magazines. Those are all indications that are not reflected in the guidelines. But perhaps the most important thing the guidelines don't reflect is the sentiment of Miss Hazel Stewart, Mr. and Mrs. Stewart, and Miss Session, when they say that this isn't something that you can put a Band-Aid on. Being a victim of a robbery in your own home, or being shot at, or being victimized is not something that goes away. And the guidelines don't reflect that. The guidelines don't reflect the fact that these victims are victimized again and again and again. Their lives have been changed. They don't feel safe in their own home because of what this man did. And that it doesn't reflect the guidelines. So I'm saying to the court could go over the guidelines. We would ask for a sentence within the guidelines because I think the guideline range is sufficient. But those are considerations that are not reflected. The defendant chose to participate in a conspiracy to rob senior citizens because he didn't want to get a job. He was a coward. He wanted to take things from other people. Personal items can be replaced. Jewelry, televisions, cash can all be replaced. But the sense of security that's lost by all of these victims, and there are up to 16 different victims identified with this conspiracy, the sense of loss of security and hopelessness can never be got back by the victims, all because of this man. And the court should sentence him based on his conduct. We'd ask for an appropriate sentence.
Thank you, Mr. Mayor. Mr. Williams.
Yes, Your Honor. Thank you very much. We were here in trial, Your Honor, for nearly 3 weeks. It was arduous, not only during the period of time that we were actually here, but the preparation for this matter. Mr. Smith continuously maintained his innocence in this particular case. And during the course of the trial, he continued to be under the presumption of innocence. With the jury verdict, he lost that presumption. And now he believes in himself and his continuing innocence and wishes to proceed with his appellate rights, of course. I think he will speak and has spoken to the probation department through the pre-sentence investigation report that you have, very tersely saying that he is innocent, he will appeal, exercise his appellate rights, continuing his belief of his innocence. Certainly we've seen an array of victims in this case, and we're worried about the community, and we're worried about the individuals. And so therefore, Your Honor, I think we're faced with the facts that we have to abide by in the case. I know that Mr. Smith may in fact want to say something more. He's not required to, but we'll see. Thank you very much.
All right. Mr. Smith, this is the date and time scheduled for sentencing. You are not obligated to speak. I understand what you commented in your pre-sentence report interview, but you do have the opportunity to speak if you wish. Is there anything you would like to say at this time, sir?
Yeah.
Okay. What would you like to say, sir?
Well, I just wanted to say something.
You can stand where you are right now. Go ahead.
My condolences go out to the victims or whatever. I didn't rob all these people or whatever. What they don't know is they didn't explain that these guys' whole plea agreement to the jurors, which was they put them in a comfortable position to say, no matter what you tell us, your minimum sentence will not enhance. So that just made them feel comfortable to say, okay, Kevin was here with me here. No, nobody in this courtroom said that I did anything to them. Even the people who said that the person didn't have on mask came in here and said I did anything to them. It's easy to put somebody behind the mask. If Robert Williams or Diego knew one of these people's sons or cousins or whatever, and they knew their name and said that they did this, they'd have been sitting in the defendant chair just by them just saying their name. And I just want to tell these people to be safe out there, because these same guys that admitted to 20 robberies, 18 robberies, finna be out here in 5 years. So I just want to tell the community, tell them to be safe about that. And I want to tell y'all prosecutors, y'all detectives, to tell Robert Williams and tell Don Diego to be safe as well when they come home. I pray for them. And that's about it.
All right. Please be seated. Please be seated. The sentencing guidelines scored in this particular case are a minimum sentence of 270 months to 900 months or life in prison. And under People v. Lockridge, the court is obliged to score the guidelines, and I recognize that they are advisory, but I will in fact impose a sentence within the guidelines. I also want to indicate preliminarily that in terms of hearing the victim impact statement from Judge Berg, that information can in fact be considered by the court pursuant to People v. Ewing, found at 435 Michigan 443, a 1990 Michigan Supreme Court decision that says that as long as the court is satisfied by preponderance of the evidence that the defendants took part in the armed robbery, that can be considered for purposes of this sentence. I do want any appellate court, however, to recognize in reviewing what takes place today that the sentence that I will be imposing is based on evidence that I think is overwhelming and shows evidence of the defendant's dangerousness to the community, really independent of what happened on Oak Drive back on March the 5th of last year. Let me start by saying There ought to be one place on earth where you can be safe and you can feel secure, especially if you're infirm, you're elderly, or you're vulnerable. In this particular case, elderly and vulnerable citizens were preyed upon, victimized, and terrorized by a group of vicious criminals led by Kevin Smith. An 89-year-old widow forced at gunpoint into her home, terrorized and robbed of items that had great sentimental value that couldn't be replaced. Items of jewelry given to her by her late husband. A retired couple enjoying life after decades of hard work, targeted because of a car. The husband who had worked for decades at General Motors, as a retirement gift to himself, bought himself a nice automobile. And because he tried to enjoy the fruits of his honest labor, he was targeted, threatened with death at gunpoint. And when his wife asked those involved in this particular conspiracy, "Why are you doing this?" there was the simple response of, "It's our job." There were two men sitting in front of the passenger's house when an attempted robbery occurred. And Mr. Smith was one of those individuals. The driver attempted to drive away when he saw the laser-guided weapon that he had. And as he drove away, 21 rounds were fired at that vehicle. Another couple, in their 20s, sitting in the driveway of the woman's home, robbed and pistol whipped. And finally, an older couple, terrorized at gunpoint in their own home. And their son, who had Down syndrome, terrorized as he viewed what was happening to his mother and his father. With masks to conceal their identity, with laser-assisted guns, this band of vicious criminals carefully selected elderly and vulnerable victims. And this band was led by the defendant. At this point in our city's history, the mayor, the city council, the police chief, community groups, business leaders, and law enforcement have been dedicated to invigorating and building the city. Many people have devoted hours and hours in an effort to make this city the great city that it is. The defendant, however, led his band of criminals on a rampage through a West Side neighborhood intent on spreading fear and evil. And we cannot and will not sit quietly and idly by and let gangsters attempt to destroy a neighborhood. We can and we must be protected from this evil. It will not be permitted to flourish. The defendant who is before the court for sentencing today is someone who was sent to prison for home invasion, for breaking into the peace and sanctity of people's home. While he was in prison for a period of 30 months, he accumulated 22 major misconducts. And for some reason, the parole board decided that someone with 22 major misconducts in 30 months should be paroled. And the result of that is that Mr. Smith was paroled for less than a month and was back orchestrating this rampage through this West Side neighborhood. In light of the danger that Mr. Smith poses to this community, it is the sentence of the court on the charge of felony firearm that the defendant be committed to the Michigan Department of Corrections on the charge of felony firearm for a period of 2 years. Since the defendant is on parole, there is no credit for time spent in custody. On the charge of felon in possession of a firearm as a fourth offender habitual, it's the sentence of the court that the defendant be committed to the Michigan Department of Corrections for a period of not less than 5 years, a period not greater than 10 years. On the charge of armed robbery as a fourth offender habitual, it's the sentence of the court that the defendant be committed to the Michigan Department of Corrections for a period of not less than 65 years, a period not greater than 90 years. There's no credit for time spent in custody. The armed robbery sentence is consecutive to the felony firearm sentence. The armed robbery and felon in possession charges, fourth offender habituals, are concurrent with one another. There's a $130 state cost, $130 crime victim assessment fee, court costs of $1,300, and attorney fees of $1,000. Mr. Smith has the right to file a claim of appeal with the Michigan Court of Appeals. If you choose to do so, you must do so within 42 days. If you can't afford to hire an attorney, the court will appoint an attorney and furnish the attorney with portions of the transcript and record that may be needed. That has to be done within 42 days. That's it.
Mr. Moran.